Now, there is so many lies and just misinformation on the internet about copyright infringement and fair use. So I want to make this video to show you the difference between the two right there.
The idea of copyright needs no introduction. It's been talked about to death on this platform. This is because many creators rely on what legal precedents state are fair use. And yet, even when they operate under these conditions, they're still continuously struck down by corporations. A lot of people think that this is an abuse of copyright, but today I'm going to argue otherwise. The issue with copyright is not just in its enforcement, but in how corporations have transformed what the idea of copyright is. What copyright is today is a far reach from what it was first envisioned as. Once a tool to protect artists, it's now used by the rich to suppress creatives. Copyright was first conceived to encourage the creation of art and culture. It was to reward creatives with exclusive rights to profit off their work. In 1790, when the first Copyright Act was passed, this protection only lasted 14 years. Once that time had passed, it would then enter what's known as the public domain. While nowadays we think of the public domain as a novelty, back then it was this expansive repository of ideas that entered the public consciousness. The first Copyright Act gave creatives a necessary grace period, but also understood the importance of modern mythology. You know how a lot of your favorite artists today began by drawing fan art? Or the websites dedicated solely to fan fiction? That's because art is inherently derivative. All artists begin by imitation, and if it's not of life, it's of other artists. The reason characters like Robin Hood, Pinocchio, or Sherlock Holmes have become so iconic are because they exist in the public domain. They were points for creatives to begin with, tropes and archetypes they could either play to or subvert. This simultaneously elevated the characters themselves into symbols. Essentially, the public domain was meant to serve as a toolbox for growing artists. With that said, who should know this concept better than the Walt Disney Corporation? Their first line of films were built on characters derived from the public domain. And yet, instead of celebrating the basis of their filmography, in true corporate fashion, they have sought to ensure no one can follow in their footsteps. Though the grace period gradually extended over the century, it wasn't until 1976 that the public domain was truly undermined. Mickey Mouse debuted in the 1928 short film Steamboat Willie. Prior to 1976, the copyright grace period had been extended to a maximum of 56 years. This meant that Steamboat Willie was only 8 years away from entering the public domain, which also would have included Mickey Mouse. Disney frantically began lobbying Congress to prevent this, and their efforts would culminate in the Copyright Act of 1976, which has since become the primary basis for copyright law in the United States. This made it so that authors were granted copyright protection for their entire life. In fact, it even extended an additional 50 years after they died. It also extended the maximum term for already published works to 75 years, meaning Mickey Mouse was now set to enter the public domain in 2003. But it didn't stop there. In 1998, Disney, along with other media elites such as Time Warner, Universal, and Viacom, continued lobbying. This resulted in the unofficially titled Mickey Mouse Protection Act, which added an additional 20 years to the copyright grace period. With no hyperbole, these two acts murdered the public domain. What was once a constant stream of creative work entering the public's hands is now, oh, that's in the public domain? Because now, by the time a piece has entered the public domain, it's become culturally irrelevant. There are rare exceptions, but the vast majority of people who held investment in them have died off. This limits both the growth of the characters and their cultural impact. The copyright on Mickey Mouse is currently set to expire in 2023, less than 5 years from now. Thankfully, it doesn't seem like they'll be lobbying again. In an article by Timothy B. Lee for Ars Technica, he reveals that internet activism made it so further legislation was impossible. An attorney for the Electronic Frontier Foundation was quoted as stating this:
"After the SOPA fight, Hollywood likely knows that the public would fight back. I suspect that big content knows that it would lose the battle and is smart enough not to fight."
But even still, it's too late. Because of their lobbying, copyright has evolved from a tool of innovation to a tool of profit at the detriment of innovation. Disney is what I'd describe as a copyright monopoly. With their purchasing of Marvel, Star Wars, and Fox, their hoarding of intellectual property is unprecedented.
How does it feel to have lived long enough to see all of your favorite franchises go down in flames?
Even if you didn't like what they were putting out before, Disney is stripping these franchises to their bones and putting out the safest films possible. And they can't be too progressive, just progressive enough to score woke points.
Wake the fuck up.
You shouldn't celebrate when Disney purchases a company like Lucasfilms. At the very least, Lucasfilms encouraged the creation of the Star Wars expanded universe, which in spirit behaved as the public domain was supposed to. These corporations will internally strike down any projects they think are too risky.
We've got to remember, Star Wars came from nowhere. There was nothing like it. Now, if you do anything that's not a sequel, or it doesn't look like one, they won't do it. That's the downside of Star Wars, and it really shows an enormous lack of imagination and fear of creativity.
And if you're a fan artist, think about how corporations treat you. Nintendo fans are afraid of the company finding their love letters because they know they'll get shut down. As it stands, copyright is a tool for corporations to consolidate characters that have entered the public consciousness, hoarding them and abusing their cultural relevance as much as possible. But what does copyright do for the smaller artist? Does copyright law in its current form protect the rights of lower-class creatives? The entire threat of suing for copyright infringement falls apart when you can't afford to take them to court. Even if it's a clear-cut case, the process of hiring a lawyer and going to court is a massive financial burden, with ultimately little payoff. In many cases, artists are bullied for their inability to stop illegal usages. One YouTuber, who I won't name here, made it a point to continue using stolen art. They taunted the artist, bragging that they couldn't take them to court. Though the artist was legally in the right, in practice, the laws meant absolutely nothing for them.
Stop it.
But going even further, it's not just that these laws only benefit larger corporations, but that they can also then overextend and use them as intimidation. There's a reason corporations like UMG and Disney file thousands of false copyright claims every day. It's because they know the vast majority of people don't have the ability to fight back.
And this is the part that might bug some people, but filing a counter notification is considered a legal action. That means that by filing it, you are essentially telling the copyright holder, fucking sue me.
In this scenario, they're not just taking advantage of an exclusive tool, but actively breaking the law to bully lower-class creators who can't fight back. As stated before, even winning a lawsuit is a massive financial burden. The mere threat of taking them to court is enough to dissuade most creators, even if their usage would be undeniably protected by fair use. A reviewer who uses the material to illustrate their points? A mother simply filming their child dancing to music? Without the existence of organizations such as the Electronic Frontier Foundation, they would be able to illegally shut down all of these people with largely no repercussions. In literary discussions, there's a concept popular amongst critics known as death of the author. It's the idea that once a work is published, the author's true intentions become irrelevant. What's more important are the interpretations of the audience. This concept can be applied to all forms of media. Films like Donnie Darko are often more interesting when we can only speculate on the creator's intention. While you may not have experienced this concept directly, you've no doubt experienced its opposite, such as the case of J.K. Rowling, who notoriously will constantly retroactively change the Harry Potter universe for the worse. Or even the aforementioned George Lucas, who many have claimed raped their childhood. When an author attempts to dictate the universe they've created, it feels wrong. Like, you want to interrogate them and ask, were you really the person behind this? Very rarely is there a single mastermind behind any franchise. And in that sense, what we consider canonical is entirely arbitrary. Are the Star Wars prequels canonical, even though the team behind the original trilogy had disbanded? Are the Disney Star Wars films canonical, even though they discarded most of George Lucas's ideas? Are they suddenly more valid interpretations of the universe because they own the rights to the property? Okay, from a legal perspective, yes, but from an artistic standpoint, no. Nothing inherently makes them true Star Wars films. And once you realize that copyright is a social construct, the idea of continuity seems to fall apart. In a world without copyright, continuity could still exist. But it would exist in the same way you group the Spider-Man films, by the team of artists behind them. New films could exist in the same continuity as previous creations, but their acceptance would rely on public reception rather than who owns the rights. With that said, I'd like to talk about the elevation of characters. As paradoxical as it sounds, a great character doesn't have to be a set of fixed characteristics. A great character can simply represent an idea. A great example of this is in Todd Phillips' Joker. I've seen a lot of people claim that this isn't a true Joker movie, that the Joker is a set of defined cartoonish characteristics, one that these gritty interpretations don't have. But I'd argue this is a gross misunderstanding of how characters evolve in culture. Much in the same way Robin Hood has come to represent the altruistic rebel, the Joker has come to represent societal disillusionment. Be it through crime, chaos, or retribution, films like The Dark Knight and Joker elevate the character beyond a Batman villain by playing to these themes. I mentioned before that the Star Wars expanded universe behaved similarly to how the public domain should have operated. Well, that comparison can also be made to comic books. Throughout the long history of these characters, they've been placed in drastically different contexts and scenarios. There's no definitive version of the Joker, Superman, or Spider-Man. There are different universes, of which you can choose your favorite. It just so happens that the Joker became the most culturally relevant of these characters. Like most forms of art, music is derivative. The most popular genre right now, hip-hop, is built off sampling. But recent legal precedents indicate that this is going to be an even larger issue in the future. In 2013, Robin Thicke and Pharrell Williams released the song Blurred Lines, which was explicitly inspired by Marvin Gaye's Got to Give Up. Despite not even being in the same key, Gaye's estate accused them of plagiarism. While stylistically similar, the two songs have entirely different structures, chord progressions, and vocal melodies. And yet, Gaye's estate won in court. In 2015, the two were found liable of copyright infringement, with the jury unanimously awarding the family $7.4 million in damages. This existentially terrifying legal precedent was upheld, even when 200 artists, ranging from Weezer's Rivers Cuomo to members of Earth, Wind & Fire, offered to give the court their expertise. Just think about the dynamic that we're seeing here. 200 culturally significant artists weren't able to win a music plagiarism case against a group of people that didn't actually produce the original work. It can be argued that if Robin Thicke hadn't explicitly credited the song as an inspiration, they wouldn't have lost. But that shouldn't mean anything. Taking a groove from a song as inspiration shouldn't be the sole reason a song is considered plagiarism. Imagine if this precedent was set for film or literature. Imagine how limited culture would become. This case just goes to show how dystopic copyright truly is. Artists deserve to benefit from their creations, but the original definition prior to 1976 achieved this. The current iteration is going to result in a dystopia where nothing new can be created without infringing on some pre-existing property. It is an unsustainable system.
See what I mean?
I'm a loser! I wish I was dead! Oh!